It is Saturday, July 11th, 2020. Hey, this is Rob Ryder. And today, Mr. President, generals and Freemasons, evasion of a promissory oath is treason. In case you forgot, I'm here to remind you. And P.S. Atheists and devil worshippers need not apply because the common law requires public officers kiss the book. And I didn't say it, it's in the book. Rob Ryder, hey, my email is quarterrecord@aol.com or phone number 616-712-6179. So, if these things are true, well, what would Freemason General President George Washington do with you, Mr. President, Generals, and Freemasons? I think he'd tell you all, hey, you're not doing it right. Right? Because he kind of set the standard. So this is... what I'm going to read to you now is going to be coming out of this manual I found from the William and Mary Bill of Rights Journal. William and Mary being, I believe that's the first university created in the United States. Or in the colonies that became the United States. And it says, kiss the book, you're the president. So help me God in kissing the book in the presidential oath of office. Well, we should be able to extrapolate that further because his oath is just a promissory oath, right? It's a particular kind for him, but everybody who's going to be in the government takes a promissory oath. So what's said in here really applies to everybody, although it's written towards the president. And that's my story. I'm sticking to it. And this is what it said. Samuel Otis, the small, short Secretary of the Senate, lifted the Bible and the red cushion from the table and took his station between Washington and the Chancellor. Otis stood with his face to the throng. The judge and the president were in profile when seen from the street. After the briefest of pauses, when Washington saw the judge was ready, he put his right hand on the Bible. Do you solemnly swear, asked the chancellor, that you, blah, 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 will, to the best of your ability, preserve, protect, defend the Constitution of the United States? I solemnly swear, Washington answered, and repeated the oath. Reverently, he added, so help me God. He bent forward as he spoke, and before Otis could lift the Bible to his lips, he kissed the book. It is done, Livingston announced. And turning to the crowd, he made a broad gesture with his hand and shouted, Long live George Washington, President of the United States. The roar of the throng came back. On an instant, joyful and sustained, Livingston's cry was taken up, and with it came clearly, God bless our president. So that's the way she was done the first time. And that is the legal precedence for how it has to be done thereafter. That's what I'm saying. And I'm going to leave it up to the common law experts and so forth to fight it out. But, that's what it says. So it should be pointed out that, George Washington at this time, he was a master mason. And this Livingston character, who was the chancellor, the highest judge in New York, was also in charge of the oldest lodge, Mason's Lodge in the States. It was formed in New York in 17 something or other. Right? So the Masons were all over in this procedure. It's in your guys' history how this was done. You should be making sure it's done this way all the time. And this is my question. Why are you allowing this shit to happen, Masons? It's your fucking fault. You're the ones with the knowledge. So we'll get into that more in a bit. So authorities have organized oaths into many categories. But the two main divisions are the accessory oath and the promissory oath. The accessory oath required the taker to acknowledge the truth or falsehood of a statement concerning actions that occurred in the past. The oath that a witness takes in court would fall into this category. Well, that's self-explanatory. A promissory oath, then, bound the swearer to perform his promises in the future. A subdivision of a promissory oath is the oath of loyalty to the state, and the oaths which are sworn by the president and federal and state officials to defend the Constitution belong to this category. Well, and to support, I would say, thank you very much. In the course of the 1530s, the government introduced general oaths loosely based on the feudal oath of allegiance to test the loyalty of English subjects. At the same time, the government substantially expanded the law related to treason. The penalty for refusing the new oaths was misprision of treason, and for a brief period, full treason. The best known recusant was Sir Thomas More, who was executed for treason because he wouldn't sign King Henry VIII's loyalty oath, even though he had been King Henry VIII's freaking chancellor and his most trusted aide. Right? So that's the way she's done. That's been done that way since 1530s, and that's the common law. And whether people understand this or not, the common law of England applies in the United States till this day. It's in the books. So during the reign of Henry VIII, failure to kiss the book upon completion of an oath of succession led to the execution of one Laurence Blunham. So this is another gentleman, the sexton of Woburn Abbey. On May 27, 1538, he confessed. The first time he was sworn, he did not kiss the book, but was passed over by reason of much company. Unfortunately, he later boasted about not taking the oath because he did not kiss the book. So he said the oath, he just didn't kiss the book. Right? Ceremony wasn't finished yet. As a result, he was tried and executed for treason. The story implies that everyone who took a loyalty oath, such as an oath of a succession, had to kiss the book just as in a judicial proceeding. The fact that the loyalty oath required Bible kissing is also suggested by a 17th century pamphlet arguing in dialogue format that the scrupulous Christian may take government oaths. It is entitled The English Manner of Swearing Vindicated, and it particularly discussed the act of kissing the Bible. An objection is raised. Some seem to object against kissing the Bible as having a greater appearance of giving too much to it or putting some adoration on it. It's answered, the ceremony signifieth that I love and approve the gospel and place the hope of my salvation in it. This is argued within the context of the oath of supremacy. See what I'm saying? You need to be a Christian to be in a public office. This is a Christian nation. Don't let them tell you different. Right? The common law of England applies in the United States. By 1778, every state boasted a treason law, and each state by 1778 created a loyalty test for all of its residents to swear. Now that would be interesting. Where's the loyalty test for residents to swear? Because I don't know any residents who swore to anything yet. But if that's what it takes to get into the Christian nation, then show me where it is. Then put me in the book, enroll me into the Christian nation. Okay, so how does that apply to today? Well, here just the other day, Chairman of the Joint Chiefs of Staff, General Mark Miley, did not hold back in an appearance before the House Armed Services Committee, stating that those officers turned their back on their oath, referring to the names on the bases. It's an act of treason at the time against the Union, against the Stars and Stripes, against the Constitution. Right? So he used these. I mean, what does he mean by Stars and Stripes? You mean against the flag? Yeah, I would say so. Against the Union? Well, what is that? Against the U.S. Constitution? How about the Constitution of the United States? That's what it's called, General. But if we're talking the same thing and just using different words, I'm okay with it. But this is what I know. Right? I'm going to listen. I got an oath that says that my oath is to the President of the United States. And because shit hasn't been done right, the office of President of the United States has not been filled. There is Donald J. Trump as the President of the United States of America, but there's no Donald John Trump as the President of the United States. Because he ain't done what frickin' George Washington did. Right? It's right here. Right? Go call a Freemason. Go down to New York. Get. They still have the Bible down there that George Washington kissed. It's got the page marked and everything. Right? They're supposed to be the keepers of all the knowledge. Go get the Masons to give up the information. But they have their own problems because they're doing the exact same thing. But this is my concern, right? I'm a enlisted man, so Donald John Trump, if you want every enlisted man to follow your orders, you need to go and do what you need to do so I can say that I can follow the orders of the President of the United States. At the same time, nobody in Congress has taken the proper oath. They've all, what's the term we use for this? Evaded. They evaded the promissory oath because they didn't put their full legal name on the oath they took. It's that simple. You can't use a middle initial. That isn't your name. Everybody has a legal identity, and that's what you need to use on documents that need to be considered official by federal agencies. It's in the Real ID Act in 6 CFR Part 37, the Real ID Act. It will define what the full legal name is. And it says in the very first part that this is the name that's used for official purposes with federal agencies. And then they define it as, your first name, middle name, last name, no initials, no nicknames. So Robert A. Rytlewski or Donald J. Trump is not anybody's real legal name. You can't use it in a legal manner. You can't put it on an oath of office. I'm not saying that Donald John Trump did. When you listen to the oath that he took in the inauguration, I just did a video on this, my last video. If you search for upload date, you see what I'm talking about. But you can go watch it online. There's supposedly the Chief Justice of the Supreme Court telling Donald John Trump, to take this oath, but it's the justice says, "So help me God," which isn't in the oath. So he wasn't giving to Trump the oath that's in the Constitution, because it doesn't say "So help me God" in the Constitution, and it doesn't have a place to put your name in it. And when they want you to put your name in an oath, they put an I, comma, and they put an AB. That's that style oath. You got to put your name in. When it just says I and it goes on to more words, well, you don't put your name in it. Now that shit's happening. So what else is going on here? So then we should go look here at the 6th article of the Constitution. Where it says that, first of all, this has actually 2 really good parts. This second part's about the oath or affirmation. But this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, and of which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary, notwithstanding. Right? The federal law applies. 4 U.S.C. 101, Title 4, United States Code 101, which has the oath that every state officer needs to take in it. If they don't take it, they don't have any authority. Is one of these laws under the 6th article of the Constitution. It also says in that article that the senators and representatives before mentioned, and the members of the several state legislatures, and the executive and judicial officers of the United States and of the several states shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. Okay, so now they define an oath as, that you're swearing to God. That's what an oath is. And an affirmation, you're not using God's name. So that was for like Quakers and so forth, so they could, take an oath without saying they took an oath. All right, so that's the gist of this, and I wanted to go through a few things, so give me just a second to regroup. Okay, so just a little, very little on the Masons. I mean, you guys already know what I'm talking about. It's just, are you going to go do it or not? But here we are. This is Livingston here. He was the Grand Master at this, what is the proper name of this thing here? All right, this is the guy who's given, he was the Chancellor. He's the highest judge in New York. That was number 1 because he was the Chancellor of the Court of Equity. And, he was the Grand Poobah at the Grand Lodge of Free and Accepted Masons of the state of New York. I shouldn't say Grand Poobah. Forgive me, I don't mean any disrespect. But I really don't know what you guys call yourselves. Okay, so now here's Michigan's, right? This is today, Grand Lodge officers. Most worshipful Grand Master, Mark Allen Manning. Now this guy's using his full legal name, and this guy's using his, and this guy is not. This guy does, this guy does, this guy doesn't, Some do, some don't. Well, what did you guys put on your oath? How did you identify yourself on your oath? And I really want to know about Mark, because old Marky here, right, he's an attorney in Michigan. And, where are we here? Right. Here he calls himself Mark A. Manning. Well, attorneys have to take oath of office to support and defend the Constitution. Where the heck is that thing? Rules right here. So I want to know what you did, Mark. All right, I do solemnly swear I'll support the Constitution of the United States, the Constitution of the State of Michigan. Right, so did you evade using your full legal name when you were doing your paperwork to be an attorney? I can't believe so, because you guys have to have this thing. All right, Michigan, although this is a cheesy looking piece of paper, but this is what they give you. When you contact the Supreme Court and ask them for the roll of attorney information for an attorney, this is what they'll send you. And it was I, Larry S. Roadster, clerk of Michigan Supreme Court, custodian of the attorney on the roll of attorneys, admitted to practice of law in the state, to hereby certify that, as appears from the records, right, somebody with a full legal name, Dean Edward Rickberg, was admitted to practice law in the courts of the state of Michigan. Okay, and I've shown before, well, this is what Dean Edward Rickberg has in this record, but when he puts his name on paper, he uses Dean E. Rickberg. So that's evading your frickin' oath. You may have taken the oath in the proper name and done it right, but you're evading it now in your practice. Okay, well, I'm saying that's the same thing that Mark is doing. I don't know if Mark meant to do that. Where are you, Mark? There you are. Because you're an attorney in Michigan. And we have some issues that need to be worked out because the person pretending to be the governor hasn't taken an oath either. She evaded her oath. And you could do something about it if you were in your full legal name and using your proper authority. Yeah, right. Okay, so there you are. This is business card. Mark A. Manning, right? This is what you get when you go look him up on the State Bar of Michigan. Well, that's not your full legal name, right? How can you use that in a legal matter, Mark? Right? If I'm required to use a legal name for legal purposes, like contracts and so forth, well, now how is it you can use a middle initial name to take somebody to court and give them a name other than their full legal name and have the plaintiff using a name other than their full legal name, and the judge isn't using his full legal name, and nobody's using their fucking full legal name? It isn't legal. So, but you could do something about it, because look what this crazy woman just did. Mark, if you pay attention, I'm sure you've read the news, but I'm going to show you. Anyways, Whitmer toughens Michigan's requirement to wear a mask with new executive order. She's not the fucking governor. She don't have an oath of office. Right? She committed treason. She evaded an oath of office to be the governor. Therefore, she committed treason by the common law. And the sooner you go arrest her ass, the sooner we can all live in peace. But first, you got to square your own shit away. Now, that's just in my state. Well, guess what? D.C., you got the same thing. Hey, how come you're using the middle initial there, Mr. Grand Master? Grand Secretary, use the middle initial. You can't do that. I'm afraid that's not your identity. But as soon as you guys straighten yourselves out, you can just turn around and tell all those people sitting in them offices. I mean, how many members of Congress are Masons? Right? I'm telling the rank and file Masons, you need to go make these people at the top follow the fucking law. Right? They're leading you, the blind are leading the blind into the ditch if they believe they can get away with using the middle initial as their identity. I'm afraid that ain't the way it works. Right? God will judge you for that, Mark. So now's your chance to straighten it out, right? I forgive, I forgive, I forgive, I forgive. I forgive everybody. Why is this? No, I just noticed, how come some people have scales? Oh, practice area. That's what it is. Look at the scales aren't even. That's interesting. Okay. You know, because here's Whitmer. Right, she's got this order, so now everybody has to wear a mask, and somewhere in here it said that, you know, because what'll happen is the local police aren't going to enforce this shit. So what she's telling them is, well, you can contact the Attorney General then. Right, so she's wanting people to narc on their fucking neighbors in the Myers grocery store because they're not wearing a mask. But she's not the freaking governor. Make her go away. Now, to show you that the common law does apply, right, this is the general provisions of the Illinois General Assembly, where it says, the short title, this act may be cited as the Common Law Act, that the common law of England, so far as the same is applicable and of a general nature, and all statutes and acts of the British Parliament made in aid of and to supply the defects of the common law, prior to the 4th year of James, right? Prior to the 4th year of James the First. Well, didn't he write a Bible? Actually, I had it written for him, but you know what I'm saying. That guy, way back in the day. Accepting the 2nd section of the 6th chapter of the 43rd Elizabeth, the 8th chapter of the 13th Elizabeth, and the 9th chapter of the 37th Henry VIII, and which are of a general nature and not local to the kingdom, shall be the rule of a decision and shall be considered as full force until repealed by legislative authority. Well, that's pretty powerful. How about in the District of Columbia? Subsection 45401, Common Law, Principles of Equity and Amity, and Acts of Congress, the common law and all British statutes in force in Maryland on February 27, 1801, the principle of equity and amity, all general acts of Congress not locally inapplicable to the District of Columbia, and all acts of Congress by their terms applicable to the District of Columbia and all other places under the jurisdiction of the United States in force in the District of Columbia on March 3rd, 1901, shall remain in force, except insofar as the same are inconsistent with or replaced by some provision of the 1901 Code. There you go. So you're going to have to show me where we ever got away from kissing the book. All right, so one more second here. Okay, just quickly so I can have gone through these things again. This is what a attorney on the roll of attorney in the state of Michigan would have as a, what they call a certificate of good standing. You should be able to get any attorney to give you a copy of a certificate of good standing, right? Now, I'm going to have some stuff to tell you in my next video about courts and so forth and things we're trying right now that are kind of interesting, what's happening. But it's really not for this video. I'm just saying, right, that every attorney is supposed to have one. So remember that. Say, well, I need to have a copy of this, of my, if some attorney contacts you, tell me you need to send me a copy of your certificate of attorney or a certificate of good standing to prove that they're an attorney. Right, so remember that. Now, if they can practice in a federal court, they're supposed to have something like this, where, right, this is the same guy, Dean Edward Rittberg, was admitted to the United States District Court for the Western District of Michigan, from the clerk's office. make them produce a letter says that they can practice in the court. This was in the Michigan Rules of Practice, I think it is. I have to look at the front page again. But this is the oath they're supposed to take, right? So they're taking an oath to support the Constitution of the United States. Well, then they can't evade it. They have to do it properly because they have to take an oath to support the Constitution. Rules concerning the State Bar of Michigan. That's what that is. So, the first law passed by the first Congress after the ratification of the Constitution was 1 Stat 23. And in this oath, or in this law, it said that the oath or affirmation required by the 6th Article of the Constitution of the United States shall be administered in the form following, to wit, I, A.B., state your name, do solemnly swear or affirm that I will support the Constitution of the United States. That's what you need to say. Now, everybody needs to say that. Everybody who is mentioned in the 6th Article of the Constitution has to take this oath. Just like it says, nothing added, nothing. Right? This law has never been repealed, so it's still a law. And this law says you need to take this oath. I, Donald John Trump, do solemnly swear that I will support the Constitution of the United States. Now, he may not need that oath for the president because he has a presidential oath, but he's also the commander-in-chief, which is an executive office of the government. So for that office, he has to take it. But so does everybody in Congress, everybody in the state legislature, all judges or executive officers of the several states or the United States. You know, we're talking everybody who's claiming authority under the Constitution has to have taken this oath and had their name after the I. Well, it ain't happening. Right? This is the oath that Whitmer filed, which right? And it doesn't have her name. So even if she had to file this oath, this isn't the oath that satisfies 1 Stat 23. Or, because it's the exact same oath, what they did is they codified it. And they put it in Title 4 of the United States Code at Section 101, where it says every member of the state legislature and every executive and judicial officer of the state shall, before he proceeds to execute the duties of his office, take an oath in the following form. To wit, I state your name, do solemnly swear or affirm I will support the Constitution of the United States. So, you know, what Whitmer's doing is she's impeding interstate commerce by pretending to be the governor and telling everybody you can't go in the store unless you're wearing a mask. Right? She's a fucking traitor who's impeding commerce. She needs to be arrested. You don't need to have any authority. You have the authority. She's a fucking traitor. Right? The National Guard could go down and arrest her. Anybody who believes you have to take a proper oath of office and follow the fucking law can go arrest her. It's the same with the Congress. Right? This is January 17, 2019, Congressional Record, the House section, starting on page H712, going to H716, where it's going to talk about after an adjournment, we're going to act like we did an oath of office, where we're going to state our name after the word I with all these other words that have been added. Now, what this is during the Civil War, they came up with the ironclad oath, which was then repealed and or found unconstitutional, actually, by the Supreme Court, modified and put in here. But when you go read this in 5 U.S.C. 3331, it says that this oath does not eliminate any other oath required by law, which is 1 Stat 23 or 4 U.S.C. 101. That oath still has to be taken. But when these people, this is supposed to be the members of the House, take this oath where IAB and they're going to put their name in, right? They've said this is the oath they need to take. This is their oath. This is their promissory oath. They are not using their full legal name. Gary J. Palmer is not this man's full legal name. Stephen C. Watkins Jr. is not this man's full legal name. They are evading their oath by not putting their fucking name on it or their identification. And the fact that the military and the Freemasons let the shit slide is, it's beyond me. You people are supposed to be watching this fucking shit. I thought you were the ones keeping all the information. You got 6,000 years of information you're supposed to be in charge of, that you're the steward of. Well, brother, it's time to buck up. So there you are, right? Now, because I found this quite interesting, I'm going to spend the rest of this video, for however long I decide to reading excerpts out of this. The gist of the video is over, right? That I'm calling out the president-elect, the generals, and the Freemasons. That all these other people, including yourselves at this moment until you get your own shit straightened out, right? You have evaded your oath of office. Period. There's no excuse. Fix it. Fix it today. Okay, what do this have to say? So let's do a little history lesson here. So on September 13, 2001, an unmarked police cruiser was driving through the empty streets of Lower Manhattan on its way to Fraunces Tavern, the historical restaurant where on December 4, 1783, George Washington bid farewell to his officers about a month after relinquishing command of the Continental Army that won the Revolutionary War. All of Lower Manhattan, including Pearl Street, where the old tavern still operates, had been closed to the public in the immediate aftermath of 9/11 attacks at World Trade Center. The Masons of the oldest Masonic lodge in New York State, St. John's Lodge, founded in 1757, were concerned about one of their most prized possessions, a decorative Bible that was printed in 1767 and had been on display in Fraunces Tavern the day the Twin Towers fell. Well, as it turns out, that's the Bible that George Washington kissed. Because the Bible that the Masons retrieved from the tavern was the Bible in which George Washington swore the oath to preserve, protect, and defend the Constitution of the United States at the first presidential inauguration, April 30th, 1789. Okay, and since then, this whole thing about this oath and so forth has been contested. And so in 2008, Michael Newbow, Reverend of the First Atheist Church of True Sciences, claiming certain religious expressions likely to occur, inauguration of the president, he didn't agree with it. Barack Obama would violate the establishment clause of the U.S. Constitution. So anyways, now this isn't the footnotes. This got a lot of footnotes, so on most of these pages, it's more footnote than it is text. But apparently in this Bible, it has this. On this sacred volume, and there's supposed to be a picture of Washington right here, on the 30th day of April, a.m., 5789, right? Not 1980 or 1789, 5789, at 4,000 years, in the city of New York was administered to George Washington, the first president of the United States of America, the oath to support the Constitution of the United States. Now, it's funny it says the oath to support the Constitution of the United States because his oath doesn't say support, right? Does it need to say the word support? I don't know. We'll see that was a question that Thomas Jefferson had. But the point is, at this time when he was taking this oath, 1 Stat 23 hadn't been written yet because this is April 30th of 1789, and 1 Stat 23 is June 1st of 1789. So what this law says is, those that were already sworn in prior to like August needed to go back and take this. So Washington should have taken this after it had been passed. But when he took the oath, it's in Article 2, well, it hadn't been passed yet. So, he did what he was supposed to. And it's been to a lot of different places since then, right? Inaugurations of William G. Harding, Dwight D. Eisenhower, Jimmy Carter, George H.W. Bush. Right? A lot of these people were Freemasons. Was Bush a Freemason? We should check these things out. So this guy had written this, and he said this time he objected to including "So help me God" in the administration of the presidential oath of office. The essential argument he made on behalf of the plaintiff was President's oath of office, as it appears in the Constitution, does not include "So help me God." Therefore, whoever administers the oath ought to recite only these words that the Constitution provides, neither adding nor taking away. I agree. Roberts should just read it the way it is. If Trump wants to say "So help me God" at the end, like Washington did, he didn't do it as part of the oath. He did it because he wanted to. The objection did not extend to the president's unprompted and independent use of the phrase. That's what Washington did. The president, like all other individuals, has free exercise rights, which might permit such an alteration. However, Newdow argued, if a government official utters the words in administering the oath, that official is not speaking in a personal capacity, but in an official government capacity. I agree. It is the government, then, that is speaking the words, "So help me God," and in so speaking, the government is sponsoring a religious belief. They just made it a religious test. The addition of "So help me God" to the constitutionally prescribed presidential oath of office violates every establishment clause test enumerated by the Supreme Court. But they never said kissing the Bible is, a violation of the establishment clause, because it's common law to kiss the Bible after you take your oath. So first you have to do it on a Bible, and you have to kiss it. Isn't that wonderful? To the counter argument that the inclusion of "So help me God" is not sanctioned by the Constitution, was nevertheless sanctioned by George Washington when he included it spontaneously at the first presidential inauguration in 1789. The plaintiffs replied that this is a myth, which apparently it is. I mean, it wasn't really the first time it was ever put into writing that happened was in the 1840s, 50s, 60s, quite some time afterwards. The recollection of some 6-year-old child who had been there. It is a matter of some consequence for the president to recite the exact words set out in the Constitution for the oath of office. Well, that would be for any oath, right? If you don't take the oath exactly the way it is, you're evading the oath. So John Roberts caused Donald John Trump to evade the proper oath by having him say, "I, Donald John Trump," and "So help me God" in the oath. He changed the wording of the oath. And so Donald John Trump was no longer taking the oath that's in the second article of the Constitution. I don't care how closely it looks. If it's not exactly the same, it's not the same. Right? Washington Irving. Irving was 6 years old in 1789 when the first inauguration was held. Historical claim based on nothing but the alleged recollection of a 6-year-old, first made more than 6 decades later, is a highly questionable validity. I would agree with that. Though Washington may not have said "So help me God" at the first inauguration, it is fairly certain that he performed another gesture of religious importance. He kissed the Bible on which he took the oath of office. The article, this article will focus on the argument that the first presidential inauguration provides no historical legal support for the spatchcocking of "So help me God" in the administration of the presidential oath. Whatever that is. What is spatchcocking? Legal significance of "So help me God" as historical precedence to the presidential inauguration. So remember now, we're talking about things that aren't in the oath, right? Like "So help me God." Well, neither was kissing the Bible. But he did both of them. Or he kissed the Bible for sure. He may have said "So help me God." If Washington himself set the precedent at the first inauguration, what would he do? He would be setting the precedence. Whatever Washington did in the first inauguration is a legal precedence for what should follow, unless it's going to be changed by a statute or a law. Right? This is the common law. It's by precedents. If Washington himself set this precedent at the first inauguration, his stature could extend the sanction of using these words to the Chief Justice, prompting the President with "So help me God," and perhaps more religious expression in a public forum. Right, kissing the Bible. And then him turning, because what did Livingston do? Right, he had a little more to do than just saying the damn thing. Oh, what did he do? He bent, Livingston announced. Okay, "It is done," Livingston announced, and turning to the crowd, he made a broad gesture with his hands and shouted, "Long live George Washington, President of the United States." Right? Where's that at? Long live the king. The king is dead. Long live the king. Right? The order of succession. Okay, so in an interview, what did he say? I think it's fascinating. It's fascinating is the interest in this because the stakes seem high for people. If you can show that he said or did not say the phrase, then certain things follow from that. I'm not sure we want our policies to hinge on that one fact. But obviously, lots of people want it settled for reasons that have to do with contemporary political life. Yes. To prove that Satan does not have a say in the government. There is no place in our government for atheist or Satanist. Period. Unless you're going to kiss the Bible, you ain't going to hold an office. Reference to what Washington is thought to have said has also appeared in very distinct, specific way in judicial opinions. In justifying government accommodation for religious expressions, Justice of the Supreme Court have cited the inclusion of "So help me God" at the first inauguration as an edifying example of a prominent place the Founding Fathers assigned to religious expression in public ceremonies. Kiss the Bible in the public ceremony. They're just talking about "So help me God," but there was also the kissing of the Bible. Kissing of the book. At George Washington's first inauguration, April 3rd, 1789, he responded, "I solemnly swear," repeated the oath, adding, "So help me God." That's what somebody said, right? At the outset of his dissent, he contrasts the strict secularism of the French Constitution with the more accommodating approach of the American counterpart, right? So Scalia is saying that the French Constitution is strictly secular, but the American Constitution isn't and has never claimed to be. The French model of strict secularism is not and never was the model adopted by America. George Washington added the form of presidential oath prescribed to Article 2, Section 1, Clause 8 of the Constitution, the concluding words, "So help me God." Okay, well, if you're saying that's why you're saying it because he said it, well, he also kissed the book. And now the Chief Justice is supposed to turn and say, "Long live the president," or whatever he's supposed to say. We should get that down. Somebody should go tell Trump. Right here, "Long live Donald John Trump, President of the United States." Donald John Trump, you need to have your oath giver proclaim that publicly. Can you put it on C-SPAN? All right, make it a public record. All right, back to the book. This book's all full of stuff. You should really download it and read it yourself. I can't hardly give it justice, going through all this. But anyways, the man who wrote the First Amendment Religion Clause did not view paid legislative chaplains and opening prayers as a violation of that amendment. For the practice of opening sessions with a prayer has continued without interruption ever since the early sessions of Congress, right? So we've always made accommodations for Christianity. Although the prayers were not offered during the Constitutional Convention, the first Congress, as one of its early items of business, adopted the policy of selecting a chaplain to open each session with a prayer. They were setting a precedence. Right? That's what common law is based on. Precedence. How did we do it before? The Marshall Court recognized that not all patterns of conduct should be preserved merely because they are historical. However, in this case, the court held that the conduct the first Congress displayed in establishing the legislative chaplaincy provides an insight into the Founding Fathers' intent regarding the meaning of the Establishment Clause. The Marsh decision carved out an exception of the Supreme Court's Establishment Clause jurisprudence, which might be applied by analogy to religious expression at the presidential inauguration if similar historical antecedents for so help me God are found, like kissing the frickin' book. If it was good enough, if they carved it out for that, then they've carved it out for kissing the book. You're going to kiss the book or you ain't going to be holding office. It's common law. Right, again, we should always go read the common law. During the reign of Henry VIII, failure to kiss the book upon completion of the oath of succession led to the execution of one Laurence Blunham. He confessed the first time he was sworn he did not kiss the book, but was passed over for reason of much company. Unfortunately, he later boasted about not having taken the oath because he did not kiss the book. The result, he was tried and executed for treason. He evaded the oath. So even if you're saying we don't need to kiss the book, we don't need to say so help me God, you still get, if it says I and you have to put your name in, you got to put your name in. Your identity, because it's official. It's a legal matter. You must use your legal name. Plaintiffs assert none of the first 20 presidents is known to have said, so help me God, after taking the oath, but the oath was so affirmed only intermittently between 1881 and 1933, and that it is not until the 1930s that the Chief Justice began adding the words after the oath. To the contrary, however, the addition of the phrase has long been traced to President George Washington's first inauguration. So what's the precedence, right? First in time. First in line is first in time. First in time is first in line. I guess that's the proper way to say it. In 2010, District Court affirmed the dismissal of the grounds that the plaintiff claims regarding the 2009 inauguration ceremony are moot. Plaintiffs lack standing to challenge the 2013-17 inaugurations. Well, how could they tell them that in 2010? That would be interesting. In his concurrence, Kavanaugh, so this is when he was on the court as a judge, not on the Supreme Court as a justice, disagreed with the majority about the procedural matters, finding the case was not moot and that the plaintiff had standing. Suggests the court that it was obvious that the plaintiffs in those matters had standing. He reasoned the injury in fact requirement was satisfied if the alleged injury is imminent, and imminence is satisfied if the injury is substantially probable. In this case, it is substantially probable that the presidential oath at this next inauguration will include so help me God, and that there will be prayers during the inauguration ceremony. History, tradition, and common sense itself tells us as much. Right? History, tradition, and common sense. It's common law. In regard to the standing issues of causation and redressability, Kavanaugh argued that the plaintiff's alleged injuries was fairly traceable to the defendants, the officers, and committees whom the president appointed to run the event. An injunction against the named defendant is therefore likely to redress the plaintiff's alleged injuries. Kavanaugh then discussed the merits of the plaintiff's motion for preliminary injunction, but concluded that the court should deny the motion because the plaintiffs could not prevail. In reaching this conclusion, he relied heavily on Marsh. This case concerns government-sponsored religious speech at a public event outside of the public school setting. The Supreme Court's landmark rule of Marsh v. Chambers set forth the court's approach to this issue. But in identifying the historical precedent that anchors the constitutionality of so help me God, Kavanaugh used the same artful language found in the federal defendant's response. Like the practice of legislative prayer used to so help me God and oaths for government officials is deeply rooted in the nation's historical tradition. By many accounts, George Washington said, so help me God, when he took the first presidential oath in New York, April 3rd, 1789. It may be true that the use of "help me God" is deeply rooted in the nation's history and tradition, but this does not mean it occurred at the first inauguration. Right, so it didn't even have to happen at the first inauguration. It's just deeply rooted. In England, they say "so help me God" on their oaths, and they kiss the book. It may also be true that many accounts indicate that George Washington included the phrase when he took the first presidential oath. But many accounts do not make this theory a reliable or even likely fact, given the lack of historical evidence extant. Judge Kavanaugh depends on secondary sources proffered by federal defendants, blah, 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 blah. So it goes on, this is what they do. They pick and choose how they want to do it. So here's the case against "so help me God." There's absolutely no extant contemporary evidence the President Washington altered the language of the oath as laid down in Article 2, Section 1 of the Constitution. I would agree. But he did kiss the book. Right? So he added those things. And now apparently there are precedents because, the Chief Justice is saying, "so help me God." Well, then he ought to be kissing the book. It would be taken out of character for Washington to have tampered with the constitutional text because he had presided over the Constitutional Convention. Well, that makes sense. That had been set out. They had set out the oath in Philadelphia during the summer of 1787, and he was a serious constitutional literist in respecting the precise words of the founding document. That founding document says all these people have taken oath to support the Constitution. And that the laws of the United States, that is the law. This is the only oath for which the Constitution gives the precise words and the only place the Constitution employs quotation marks. There you go. Right? "I do solemnly swear and affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States." Now remember, Roberts adds, "I, Donald John Trump." This does not say to do that. All right? You're supposed to just say it, just the way you see it. So Roberts is not following the words of the Constitution. And it didn't show that Livingston said that in the first one. Let's see. "Do you solemnly swear?" Right? It didn't say, "Do you, George Washington, solemnly swear?" It just said, "Do you solemnly swear?" And then Washington didn't say, "I, George Washington, solemnly swear." He just said, "I solemnly swear." Right? There's no place to put the name in the presidential oath. Aye, aye, aye. In his book, "So Help Me God," Founding Fathers' first great battle over the church and state, the Reverend Forest Church, defends the accuracy of Irving, witness observing that Irving, though 6 years old, was clearly correct about Washington bending down to kiss the Bible. Right? Forget the "so help me God." He got to kiss the Bible, right? So, they had that was already written in that's what Washington did. And this guy is remembering that. So him saying he said, "so help me God," is a really good chance that that's what he heard. All right, here's where Samuel Otis is doing the business I was talking about. "I solemnly swear." They received the president in the most respectful manner, and the vice president conducted him to the spacious elevated seat at the head of the room. A dead and solemn silence prevailed. In a few moments, the vice president arose to inform the president of all things were prepared to administer the oath whenever he saw fit to proceed to the balcony to take it. He immediately descended from his seat, advanced through the middle door of the hall to the balcony. The oath was administered to the public by Chancellor Livingston, who's the frickin' big dog at the state level Mason's Lodge. And the moment the Chancellor proclaimed the President of the United States of America, the air was rendered repeat with shouts and hoorays. "God bless our Washington." Now, he didn't say United States of America. He said President of the United States. That's why this is an uppercase, because this isn't what he said. The oath was administered in public by Chancellor Livingston, and the moment the Chancellor proclaimed the President of the United States, proclaimed him President of the United States, that's what he did, right? That's what it says he did up here. Long live George Washington, President of the United States. That's in quotes. That's what he said. This isn't in quotes. This isn't what he said. Chancellor proclaimed him President of the United States. End of statement. Justice Scalia, citing Robert F. Blomquist, the presidential oath, the American national interest, and the call for something or other, Blomquist in the turn cites Michael Nelson's Congressional Quarterly Guide to the Presidency. I'm pointing these out like, there's all these other documents to go read on this subject that are just, that's what this guy did. He spent the whole book giving footnotes, right? Where to go get more information. Yet the belief that George Washington and others, help me God, the first presidential inauguration is still resistant to correction or even reasonable qualification. We're just not going to hear it. That's what he did, and he kissed the Bible, so get over it. I rejoice in the exaltation of a person to the head of the Union who professed himself to be a Christian, who is not ashamed to confess Christ, glory in his cross, and publicly honor his institutions, and hope and pray that all our rulers may follow his illustrations, his illustrious example, and be politically as well as religiously wise to promote both the law and practice the best interests of the country by promoting the Christian religion. So nobody else has a choice. The head of the Union did it. Everybody else has to do it. I don't think I showed it, but in the beginning it said that what he kissed, because they marked the page, was Genesis chapter 49 and 50. If you want to go read those, right? That's the page he chose. And this goes in some here about talking, that everybody knows. You throw the Bible down or set the Bible down, open it up and read, right? When you're looking for an answer, well, just open the Bible and read. And there'll be an answer. It just seems to be that way. It's the power of God, right? So the question is, well, did he just open that page or did he do it on purpose? And they did point out that, by and large, that the presidents that did it, it was all done just, by opening the Bible to a particular page. But one of the presidents actually picked the verse that he was going to kiss. I meant to write it down and I didn't do it. So I'm going to go back and find it. But continuing on, the other argument advanced by church refers to a letter of March 2nd, 1801, in which Thomas Jefferson, now we get to 1 Stat 23 stuff. So, the other argument advanced by church refers to a letter, March 2nd, 1801, in which Thomas Jefferson poses a question to Chief Justice Marshall regarding his upcoming inauguration. I would pray you, in the meantime, to consider whether the oath prescribed in the Constitution be not the only necessary to take. It seemed to comprehend the substance of that prescribed by the act of Congress to all officers, and it may be questionable whether the legislation can require any new oath from the president. Church writes that he could conceive of no other reason for Jefferson's question apart from Jefferson wishing to assurance from Marshall that he would not be required to add the words "So help me God" to the oath spelled out in the Constitution. The "So help me God" article, however, provides a far more plausible explanation. Jefferson merely wanted the Chief Justice's opinion regarding whether the president-elect he had to recite both the oath prescribed for the government officials of June 1st, 1789, that's 1 Stat 23, June 1st, 1789, an act to regulate time and manner for administering certain oaths, right? That of Congress, as well as the presidential oath found in the Constitution, or only the latter. Chief Marshall's response was, the records of the Office of the Department of State furnish no information respecting the oaths which have been heretofore taken. Now that's interesting. The records of the office of the Department of State furnish no information respecting the oaths which have been heretofore taken. Why are they not in the Department of State if that's where they're supposed to be? Where did the Chief Marshal go to look to see if it had been done? He went to the office of the Department of State. They furnish no information respecting the oaths which have heretofore been taken. There's no record of them there. That's where they need to be. They need to be in the frickin' Department of State. The oath prescribed in the Constitution seems to me to be the only one which is to be administered. I shall, however, inquire what has been the practice. So I'm saying this, okay, well, fine, you don't need to take it as the president, Donald John Trump. You need to take it as the commander-in-chief. You have two different offices. And the commander-in-chief is an executive officer, and all executive officers have to take the oath. So there you be. On April 6th, the House of Representatives appointed a committee prayer bill to regulate the time of taking the oath. All right, so this is about 1 Stat 23. This is, in April. The oath that they'll have done in June, we're putting together in April. The initial wording of the oath the House approved included religious expression. I, A.B., state your name, a representative of the United States in Congress thereof, do solemnly swear or affirm that I will, in the presence of Almighty God, that I will support the Constitution of the United States. So help me God. That was the way it was first written. Right? They had every intention of putting God into the oath and having you put your name in it. All right? Now, the bill passes on the 27th, April 27th. The House reads the approves the bill, which specifies, I do solemnly swear I will support the Constitution of the United States, and forwards to the Senate for its consideration. Now here, they don't have any place to put the name in. All right? But it ends up that way in the law. So now it's going to go to the Congress, and they're going to do their thing, shake and bake. At some point, we're going to put it into the 1 Stat 23. Mr. White presented, according to order, a bill to regulate the time of taking of oaths or affirmations prescribed in the 6th Article of the Constitution, which was received and read for the first time, right? Prescribed by the 6th Article of the Constitution. Why are we here? We're here to regulate the taking of the oath or affirmation prescribed by the 6th Article of the Constitution. That's 1 Stat 23. You can't satisfy the 6th Article unless you take that oath. The bill regulating the manner and taking of the oath prescribed by the Constitution was committed to the Committee of the Whole. After proceeding some time and considering it, the committee rose and reported progress. Well, that's good of you. May 6th, the House agreed to amendments. On May 7th, the Senate agreed. George Washington signed the bill. An act to regulate the time and manner of administering oaths on January 1st, 1789, and the final words of the oath excluded any religious expression. I do solemnly swear or affirm that I will support the Constitution of the United States. Well, that isn't what they put in here. This got I-A-B. Right? So somebody's lying. Either this is a lie, that these aren't the words put in, or this is a lie. But I'm going to go with the fact you're supposed to put your name in. Come on, go down there. Okay. Well, what else do I have here that I did? Received the House bill to regulate time, manner, administering oaths. The amendments concern the addition of state legislatures, executive, judicial officers appointed before August 1st to take the same oath within a month after the appointment, and the state legislators, executive, judicial officers appointed after the 1st to take the oath before they begin the duties of their office, which is where we are today. This is why in 4 U.S.C. 101, right, before the governor can issue any order, she had to take this oath. And federal law trumps state law. So the head Freemason of Michigan ought to be, because he's an officer, if he took the proper oath and so forth, he's an officer in the government. He needs to be filing a suit against her and have her, whatever it takes. What do you call it? Impeachment for treason. She wants to say she's the governor, then say that she committed treason by evading the oath. Otherwise, she's just an imposter, a common criminal, a traitor, committing treason, or terrorism. Right? Treat her that way. I don't care how you do it. Make it civil, make it military. It doesn't matter to me. She just needs to go. So does the Attorney General. So does anybody else who doesn't want to take the oath. They get one chance to do it right. Washington did not introduce "Help Me God" to the presidential oath, or at least the evidence is not strong enough to say that he did. Okay, so they say first-hand accounts of the biblical kiss, though. Those who have most forcefully attacked the myth of "Help Me God" do not seriously question Washington's biblical kiss. Henriques, for example, accepts it as fact. Many founding fathers were religious. George Washington kissed the Bible on which he took his oath. Right? Because you had to have a Bible to take an oath. This is all common law coming out of England that was brought here, and that's the parts that they decided to follow. And if that's not ever been repealed, or nobody's ever written a law that says that you don't have to use a Bible to take an oath, then you need to use a Bible to take an oath. They didn't write a law that says you don't have to kiss the Bible. Well, then you got to kiss the Bible, because the precedent had been set. The next impressive spectacle I witnessed was far more interesting and important than any I had yet seen and since beheld or ever expect to see. It was the inauguration of the first President of the United States. This auspicious ceremony took place under the portico of the Federal Hall, upon the balcony in front of the Senate chamber, and in the immediate presence of both houses of Congress. The oath was administered by Chancellor Livingston, and when the illustrious chief had kissed the book, the Chancellor with a loud voice proclaimed, "Long live George Washington, President of the United States." After assembling in front of the President's house, it proceeded through the Queen, now Pearl, to Wall Street, to the Federal Hall, at the head of Broad Street, upon the upper portico from which the oath of office was administered. The President-elect, in the presence of both houses of Congress, by Robert R. Livingston, Chancellor of the State, and the head Mason of the state. And so what is this Federal Hall anyways? Right? Is that where the government still is? Is the government being run out of that hall down on Wall Street? Queen and Federal Wall Street? Right? Because, the government can run from wherever it needs to. It may have gotten run out of the District of Columbia. Right? The government of the United States, and it's been replaced by these invaders from the United States of America who are pretending to be the government, but they've not taken the proper oath. They evaded their oath. They're a traitor. Right? I was on the roof of the first house. So these are all first-hand accounts. He was also the master of St. John's Masonic Lodge and brought the Bible and his cushion from his lodge. After Washington kissed the open book, Morton is said to have stepped forward to retrieve the Bible and folded the corner of the page to which the president had kissed the book. And again, it was apparently it was Genesis chapter 49:50. Yeah, read this already. Attending him, Secretary of Senate, seat inclined to right, Vice President carrying a Bible on a cushion. The Chancellor of the State administered the oath. The President laying his hand on the Bible, repeated the oath. After which the President of the United States kissed the book, and the Chancellor proclaimed him President of the United States. Long live George Washington. Where was that? Where was that from the Chief Justice? Subsequent traditions. But in regard to kissing the Bible, the first president to renew the custom after Washington was Andrew Jackson at his inauguration in 1829. 1833, the gesture was not recorded again until Abraham Lincoln took his oath in 1861. After Lincoln, presidents maintained the custom with a degree of consistency until it was finally abandoned by Dwight Eisenhower at his first inauguration in 1953. Why? Is he not taking the proper oath? Right? I mean, can he change the precedence of what we're doing for an oath? Now, I guess he can because he's the commander-in-chief. Well, no, excuse me. He's like the king, right, of our nation. So if you look at him in that light, I guess he could. All right, here's all the people that kissed the Bible. Andrew Jackson, Grant, Hayes, Garfield, Arthur, Cleveland, Harrison, McKinley, Roosevelt, Taft, Wilson, Harding, Coolidge, Herbert Hoover, Harry Truman. There we go. Who did what? Got a whole list of them. Yes, 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 yes. There's a lot of yeses there. But Roosevelt didn't, right? Franklin didn't, but Teddy did. When I was an associate in a large law firm, one of my earliest assignments was to prepare a memorandum in support of summary judgment motion. The partner who reviewed my finished work had one major criticism. I had used the title Prayer for Relief for the concluding section, the one in which attorney states that the attorney is asking the court to do. In law school, I had learned that this was the common acceptable title for this section. In explaining why he wanted the title for this section changed, however, the partner supervising my work tardily observed that he supported the separation of church and state. All right, so he's evading his oath. Whatever one might think of this application of separation doctrine, the partner's observation had often led me to contemplate the difficulty in completely purging legal language of religious term and meaning when the language of the law was often historically conceived in religious context, with the result that many common legal terms still retain religious connotations. The oath is a good example of this, for it is a word that nearly as much religious content as prayer. The ancient history of oath. The oath is an artifact of pre-religious animalistic past, conditional self-curse that operated automatically by virtue of inherent magic of the word or gesture. When a human culture developed a belief in supernatural divine beings, the oath ceased to operate independently as magic, but rather relied on the gods to exact vengeance for perjury or faithlessness of the oath. The ancient Greeks' word for oath refers to the son of Eris, the goddess of discord. According to Hesiod, Orkos, is the divinity who punishes the false and the perjured. Hence, the oath is a device to restrain the discord of falsehood and promote order of truth. Yes, sir. During the 6th century, the Roman provisions requiring testimony oaths be incorporated into the Code of Justinian. Been around a long time. That'd be some common law. Okay, this is that oaths have been organized in many categories. You got your accessory and your promissory. Accessory is like what you use as a witness. Promissory is like what you use as loyalty to the state. Oaths which are sworn by the president and federal and state officials to defend the Constitution belong to this category. They're a promissory oath. At the time of Washington's inauguration, the state of loyalty oath had been experienced a long, tortured history in England and in the colonies. In 1716, Thomas Bede, writing history of the oath started to ascertain that no nation in the world has invented more varieties of state oaths. He was referring to the development that began in 1534 when Henry VIII, in an effort to extend his government's power and control, modified both the English coronation oath and feudal oath of allegiance to give the king unconditional authority over both church and state. Over the next 2 centuries, British government demanded a variety of loyalty oaths of political and religious allegiances. In the course of the 1530s, government introduced general oaths loosely based on the feudal oath of allegiance to the test of loyalty of English subjects. Yeah, I got it. Best known recusant was Thomas More. Right? These oaths of allegiance included the Elizabeth Oath of Supremacy, 1559, Oath of Allegiance of 1606, the Sacred Vow Covenant taken by the Lords and Commons and settled in Parliament in 1645, the Solemn League and Covenant, 1643, the Engagement, 1649, the Protectorate Oath of 1654, the oath supporting the Restoration, 1611 to 1661 to 1665, oath supporting the Glorious Revolution, 1688, and the anti-Catholic oaths. Taking these oaths created difficulties not only for Catholics, but also for religious dissenters of tender conscience who, like many early Christians, believed it was sinful to swear to God in name. The imposition of oaths over the course of the 17th century required English subjects not only to conform to the shifting allegiances between the church and state, but also to swear a solemn oath of allegiance to the king, and then betray that oath and substitute it with another solemn oath of allegiance to the Parliament, and then to betray that allegiance and pledge loyalty once again to the king, and finally betray the allegiance to the king in favor of another chosen by Parliament, which seemed likely to result in skepticism and cynicism regarding the significance of all of these oaths. But the oath and the constitutions never changed. See, they did this over and over and over again, but these first oaths, they've never changed. They're the way they were when they were first written for our nation. The oath in Article 2 and the oath in 1 Stat 23. They have not changed. By this oath, King James attempted to separate politically disloyal Catholics from those who accepted the Protestant monarchy. There we are, King James I. The English colonists who came to America faced more conflicting oaths. Not only did they have to swear to the English oaths, as did, for example, the settlers of Virginia, but also oaths to the colonial governments, as did the settlers of Massachusetts Bay, who in 1634 drew up their own oath of loyalty to the Commonwealth of Massachusetts rather than to the king. Right? They're separatists. As for the War of Independence, loyalty tests played a primary role in structuring the Revolution. To oppose the British tax programs, the colonists organized boycotts enforced by oaths. In 1774, the Continental Congress designed the colonist first standard loyalty test. With practice efficiency and bland assurances of continued loyalty to the king, Whig committees enforced the provisions of the oath by social ostracism, economic pressure, and physical terrorism. In the course of the war, colonists found themselves forced to sign loyalist oaths and then rebel oaths as the lines of occupation shifted between the two armies. By 1778, every state boasted a treason law. Each state had, by 1778, created a loyalty test for its residents to swear. Do we still have that today? If we do and somebody can find it, would you please send it to courtofrecord@aol.com. Tell me about it. Loyalty oaths again played a vital role during the Civil War, as both the North and South used them to gain control over the population. According to Hyman, Lincoln deployed an effective policy of offering to captured rebels or our imprisoned Confederacy sympathizers generous terms of clemency, provided that they sign the oath of loyalty to the Union. Where is it at? The Civil War is still going on. There's never been a peace treaty. Right, we got gold fringe flags in courtrooms. Brother, we're under martial law. We have been since 1861. And I'll tell you right now, this will be in my next video when I get a chance to. I'll try to get Joe and his son on a recorded call. But a guy named Joe told me that just last week he told the judge, "Well, Judge, you got a gold fringe flag in your courtroom here. Why don't we call the general in and make him a witness?" And after he said that, the judge cleared the courtroom. And the rest of the story shall follow. It was during this period that, so help me God, made a comeback. In an effort to keep Confederate sympathizers out of government office, Congress substantially expanded the language and appended, so help me God, to the oath required by government officials by Article 6 of the Constitution, right? Reversing omission of the 1789 Judiciary Act. Now, I don't see how they can put so help me God to the oath required of government officials in Article 6 of the Constitution, which specifically says there cannot be a religious test. And so they wrote another one, which we call 5 U.S.C. 3331, the one that they're taking and the one that all these other officers in the of the United States apparently take, right? But it has a religious test. But that law says this oath does not replace any other oath required by law, which is the oath in 1 Stat 23. They still have to take that one. Anyways, the Supreme Court declared the so-called ironclad oath unconstitutional as a bill of attainder and a law ex post facto 1968. Whatever the hell that means. Okay, so Lincoln would trust the seemingly innocent man who, seeking freedom, would pay for it by swearing a loyalty to the federal government. Amen. I thought I did that with my oath of enlistment. Lincoln's mercy was the mercy of trust in the honor of Americans, buttressed by his view of presidential power. An act to prescribe an oath of office and other purposes. Chapter 128, 12 Stat 502 of 1862. The text of this oath is as follows. I, Robert Allen Rutluski, do solemnly swear or affirm that I will never voluntarily bear arms against the United States, since I have been a citizen thereof, and that I have voluntarily given no aid, countenance, or counsel, or encouragement to persons engaged in armed hostility thereto, that I have neither sought nor accepted nor attempted to exercise the functions of any office whatever under any authority or pretended authority in hostility to the United States, that I have not yielded a voluntary support to any pretended government. Right, that's what we got now, pretended governments. Pretended government, authority, power, or constitution within the United States, hostile or immissile thereto, and I do further swear or affirm that to the best of my knowledge and ability, I will support and defend the Constitution of the United States against all enemies, foreign and domestic. I will bear true faith and allegiance to the same, and I will take this obligation freely, without any mental reservation or purpose of evasion, and I will well and faithfully discharge the duties of the office for which I am about to enter, so help me God. Okay, well, I think we could all take that oath. Right, now who do we give it to? Right, Vic Snyder says you've taken an oath to support the Constitution. Now what? Well, maybe he tells us. So here's all these other books to read for a little more depth in this, but I'm telling you, man, the Freemasons already know what's supposed to happen. I want to know why they're not doing it. On May 13th, 1884, Congress made the 1860 oath, one that the federal and state employees would take, and it remains in this place today, retaining the words, so help me God. Aside, right, this is for federal and state employees would take. Well, a member of the Congress is not a federal employee. They're a branch of government. Right? But that's the oath they're taking. This is how you can tell they're not who they say they are. They're taking an oath of an office, and if you read the 14th Amendment, it says that a member of Congress can't hold an office. Right? They have to be a member of Congress. It's not the same as holding an office in the government. It's a separate branch of government. Aside from the presidential oath, federal oath for government officials under discussion oaths are commonly required for a variety of professional endeavors such as military, university, and the bar. Oh, no figure. Amended reads as follows. Right, so this is the 14th Amendment. No person shall be a senator or representative in Congress, or elector or president or vice president, or hold any office, civil or military, under the United States or under any state who have previously taken an oath as a member of Congress, or as an officer in the United States, or as a member of a state legislature, or as an executive judicial officer of state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof, but Congress may, by a vote of 2/3 of each house, remove such disability. Well, by them concealing their name, right, they evaded the frickin' oath. That's what I'm saying. They evaded the oath, and evading the oath in common law is treason. Courts eventually accommodated such Christians by allowing them to affirm rather than swear. Right? So you can swear or affirm. That's what Christians can do. At common law, only Christians could swear an oath and therefore testify in English courts because only Christians could swear by the Bible. So when you say that you swear, you're doing it as a Christian oath. At common law, atheists were considered incompetent to give testimony because the atheist did not believe in God. The atheist did not believe in divine punishment for perjury, and therefore the oath could not be used to ensure such a person was telling the truth. And anybody who follows the devil, which is the father of all lies, are just born fucking liars. There's nothing they can do about it. They lie, cheat, and steal all the time. And you can see it happen every day. Just read the news. Lie, 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 lie. Although a promissory oath, the type of oath sworn by presidents, is arguably subject to many of the same infirmities as an accessory oath, this oath has its defenders in commentaries like Sanders, Lewinson, and Matthew Pauley. So the point is, we're talking about this being an accessory oath, which isn't the same as a promissory oath, which is really what we're talking about in this lecture, is the promissory oath. Well, the promissory oath, it's going to be the way they say. Perhaps the most significant defense of the religious oath was advanced by Simon Greenleaf in his treatise, The Law of Evidence. To design an oath is not to call the attention of God to the man, but the attention of man to God. Not to call him to punish the wrongdoer, but on the man to remember that he will. Thus, the oath survives because it has engaged the religious scruples of the conscience of the oath taker, and therefore provide the state with some leverage in persuading this person to tell the truth, to take serious the commitments undertaken by the oath, yada, yada, yada. So you just have to say, look, we don't have any separation of church and state in the United States. You have to be a Christian if you're going to serve in the government. There is a great deal of evidence that the framers of the Constitution supported promissory or loyalty oaths. The primary evidence of the support is their inclusion of the presidential oath, Article 2, and the oath of federal and state officials in Article 6. Thomas Jefferson supported loyalty oaths to control the Tories, those Americans who opposed the Revolution. In 1782, he wrote, "A Tory has been properly defined as a traitor in thought, but not in deed. The only description by which the laws have endeavored to come at them was that as non-jurors or persons refusing to take an oath of fidelity to the state." Jefferson goes on to explain that although the Tories are subject to triple taxation, the leniency of American rebels is evidenced by the fact that they were never executed for treason. So because we haven't taken whatever this thing is we're supposed to take to prove our loyalty, right, the citizens' loyalty thing, we're being treated as these non-jurors or persons refusing to take an oath of fidelity to the state. We're being treated as a Tory. And so we're getting double and triple taxed. Right? If we would go take the oath, all them taxes would go away. In an article discussing the Constitution as charters of government, James Madison wrote, in Europe, charters of liberty have been granted by power. America has set the example, and France has followed it, of charters of power granted by liberty. Who wrote this here? James Story, an eminent early scholar in constitutional law, emphasizes the religious foundation of the presidential oath of office in his 1847 exposition on the Constitution, that no man can doubt the propriety of placing the president under a sanction of the oath of office, let it not be deemed a vain and idle form. In all these things, God will bring us into judgment. A president who shall dare to violate the obligation of his solemn oath or affirmation of office may escape human censure, nay, may even receive applause from the giddy multitude, but he will be compelled to learn that there is a watchful providence that cannot be deceived, and a righteous being, the searcher of hearts, who will render unto all men according to their deserts. Considerations of this sort will necessarily make a conscientious man more scrupulous in the discharge of his duty, and will even make a man looser principles pause when he is about to enter upon a deliberate violation of his official oath. This just doesn't apply to the president. It applies to everybody in Article 6. All have a solemn obligation upon the minds of all reflecting men, and especially upon those who feel a deep sense of accountability to the Supreme Being. But among the Founding Fathers, perhaps the strongest supporter of the oath was Washington himself. During the Revolutionary War, Washington advocated the loyalty oaths, even before a Declaration of Independence was written. In 1775, he wrote, "It's high time a test act was prepared, and every man called upon to declare himself, that we may distinguish friend from foe, nor have I any idea of a man being exempt from the common duties of society and country or community when they have been fostered in the sweet enjoyment of liberties." From the first institution of civil government, it has been the national policy of every precedent state to engage its members to the discharge of their duty by the obligation of some oath. Its force and happiness and happy influences have been felt in many instances to need any arguments to support the policy or prove its utility. An oath is the only substitute that can be adopted to supply the defect of the principle. Okay, well, hey, I'm done. I'm getting tired of reading this, but you can see where this is headed. You know, that these are the things you need to do. I kind of feel that this, that an oath of enlistment is what they're talking about, is this oath that everybody's supposed to take. Right? I, Robert Allen Britluski, do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear truth, faith, and allegiance to the same, and that I will obey the orders of the President of the United States and the orders of the officers appointed over me according to the regulation, Uniform Code of Military Justice, so help me God. I believe that that's the oath that is even supposed to be taken by people that, by everybody who went to selective service. Because in the selective service, they're supposed to register you, certify you, and test you. Right? And they're certifying everybody as a 1H instead of being certified through a board the way they're supposed to be. They give everybody the status of 1H, which is not a good status. Right? 1A is what you get when you're in the military. If you're able-bodied and able to serve unrestricted, you're a 1A. But they don't give anybody a 1A. They give everybody a 1H. And they're not giving this oath. I'm saying this is the oath that they're talking about, that every man, woman, and child, when they reach adulthood, needs to take this oath. Right? That I will obey the orders of the President of the United States. That's what makes you a citizen of the United States, the fact that you obey the orders of the President. This is the oath that makes you a citizen of the United States. And so myself, I am one now, as is every other veteran, but we're not getting our props for being one because we don't have a President of the United States because Donald John Trump ain't taking the 2 oaths of office he needs to do it. So help me God. Okay, that's where we are today. And let me just stop for a second and make sure there's nothing else I want to add. So hang on here. No, I don't think so, Mr. President. Generals and Freemasons, evasion of a promissory oath is treason, and it's happening all over the place. No atheists or devil worshippers need apply for any office in the government of the United States because they're unqualified. Common law requires public officers to kiss the book. So, you're looking for what to do, go see what President George Washington did. He was a Freemason, a general, and a president. And he took his oath in New York. And so the Freemasons in New York, they have all the information on how he did it. Right? So what I want to know is, well, Freemasons, are you taking an oath using your full legal name? If not, you're not upholding your bargain with God if you believe that you get to hold on to all the information. Right? You have evaded a promissory oath. And that's treason and worse. Okay. You'll have a great day. Let's see if we can get this thing straightened out. Oh, by the way, after they cleared the courtroom, they called Joe and his son back in. And the judge said, I'm going to recuse myself of this matter. And some more. And so I hope to get all this on tape, and I'll share it with you. That and some other stuff that's going on. In my next video, Lord willing. Okay.